first time that I've seen such a situation, either at the High Court or the Supreme Court, where someone will be cross-examined via a video link. And so it's not something that I have personally encountered, at least in the last 5 to 6 years. And so it's quite new. And when we got into the courtroom, we saw the setup. He had actually already connected, but his video had not been turned on yet. And so we're looking forward to see how this is going to be carried out, even with issues of the sound and how stable would the connection be, and among all those other issues were all concerns that we all had. And so we're looking forward to see how that was going to pan out. But I mean, as you did indicate, it was quite a brief session as a result of the fundamental concern that was raised by Mr. Kotampao.
We could see somebody on the television right behind the justices, but you had a closer view. Can you describe the environment where he is connecting from?
The person seems to be in a room. It looks like a room, and he seems to be sitting behind a laptop. Obviously, he's wearing a mask, like I could see from where I was seated, and that individual, we understand, is Mettle Nunoo. In the course of the video link, we could see him turning, and he appeared to be interacting with someone. In fact, a member of the panel had raised the issue that because it is a video link, if he is being assisted by someone, it could be seen. So at that moment, Mr. Kotampao was asked to look at the video. And just when he turned to look at the video, we could see Mr. Nunoo turn and appear to be interacting with someone. So then Mr. Kotampao at that point made it clear that, look, as I was saying, he's actually interacting with someone, and we do not know who that person is. And so it's important that my request is granted. And Mr. Chikata did not oppose that request, and so the court proceeded to have that officer dispatched. Then, in fact, right when we came out, a dispatch rider with a four-wheel drive vehicle of an individual inside that we are told is that judicial officer left the premises of the Supreme Court. And so we understand that within some 20 to 25 minutes he should be at that particular location where Mr. Mettle Nunoo is testifying from. Again, if you heard a question that Professor Kote, a justice of the Supreme Court, asked Mr. Chikata, he said, how close can this judicial officer be to the witness when he even goes over to the place? And so Mr. Chikata did respond, and Professor Kote did state that he was asking that because of what Mr. Chikata had told them about his condition on a previous day. And Mr. Chikata responded that there's a medical officer there who will supervise the whole thing, and so once he goes over, and also due to the number of days, he can only say that it should be safe to get close, but once they get over, the medical officer will assist them. And so that is by way of what we know about what the situation is with regards to his condition and why he's testifying away from the court and not in the courtroom as the others before him have done.
Great, and I must add that it was actually Mr. Chikata who had suggested that an officer could be dispatched to this location, a suggestion that the court obviously welcomed. And Joseph, we're just going to show what you described a while ago, the judicial officer as he was dispatched to this location where Mettle Nunoo is testifying from this morning. So as you can see in your shot, and this happened a while ago as he was being driven to this location. This is the judicial officer who will be with or by Mettle Nunoo when he gives his testimony this morning in about, I guess now in about 20 minutes. We're looking forward to that. But Joseph, Justice Anini did indicate that the modalities for this evidence had been extensively discussed. Is there something more that we know beyond what we've just witnessed?
And so we also know that there is going to be an initial objection raised by President Akufo-Addo's lawyers, like they did in the case of Johnson Esiedun Ketia, about the contents of the witness statement. And you heard Mr. Kotampao briefly touch on what the first concern is. It relates to the latter part of Mr. Nunoo's witness statement, a copy of which I know you have. If you read the bottom part, he makes the point that he swears to paragraph 1 to paragraph 16. But the witness statement actually has more than 30 paragraphs. And so he attests to the fact that the issues mentioned in paragraph 1 to paragraph 16 are matters that are within his personal knowledge. And so we understand that President Akufo-Addo's lawyers will be raising the objection that it means that the remaining paragraph beyond the paragraph 16 are not matters that he can confirm, and so those portions should be set aside from the witness statements. And we understand that Mr. Chikata, who represents the petitioner's side, will be responding to that particular objection and disagree with it, and so that will be an issue that the court would have to resolve once the judicial officer gets over to the premises. We also get in a sense that there could be the potential that there are contents that there are matters that have not been pleaded in the petition itself, and so that is the indication that we are picking so far about the potential objections that could be raised, and so we are looking forward to that particular thing happening once the judicial officer gets over to Mr. Nunoo's location, which we are told is not very far away from the Supreme Court premises. Mamavi.
It's interesting, the objection, and we're glad that we have that information now, even before the court gets into the matter, because Akutu Ampao had talked about it. So if you look at paragraph 1 to 16 of the witness statement, what I guess a lot of people will be looking forward to would be the portions where it talks about the communication, the alleged direct communication with the Electoral Commission boss, and that you would find specifically in paragraph 23, which is not part of the 1 to 16. So I'm just going to read paragraph 23 and 24 combined. It says, Mrs. Jean Mensah informed me that there had been a meeting held earlier in the day between the petitioner and the Peace Council, something I was unaware of at the time. After I further drew her attention to some of the issues that were coming up in the interactions in the strong room, she said very directly we should go and speak with the petitioner. Having regard to her earlier reference to the meeting between the Peace Council and the petitioner, which she had obviously been briefed about, I took seriously what she said. I did not think that we, who were acting as agents of the petitioner, should be seen as taking positions which may be contrary to what the petitioner himself had conveyed in the meeting that I was unaware of with a body such as the Peace Council, which I know has an important role in resolving disputes in connection with elections and calming tensions in the country. She indicated her own willingness to meet with the petitioner. Paragraph 24 reads, I was also struck by the fact that she proposed that she would send a dispatch rider to help us get back to the headquarters of the EC ahead of time for her own exercise of her responsibilities. There was nothing in the discussions which could have given me any reason for doubting the word of the chairperson of the EC. Indeed, having worked with her previously when I was a consultant to the IEA, I had no reason not to trust her. I took her at her word, and I must say I was really shocked to realize how she had proceeded to make a declaration of results at a time when she knew that my colleague and I had left the premises at her instance. I can still remember her saying that she would even send a dispatch rider to hasten our return to the EC headquarters after our consultations with the petitioner. And Joseph, these two paragraphs, the question that was put to Dr. Kwesa by the bench, sort of answers or brings out some of the things that people will be looking forward to, that his testimony would cover, since he directly could speak to some of these matters. It would be totally disappointing if this is not part of the statement, Joseph.
Yes, Mama V, and it's important to put it in the context of how important it is to the petitioner's case, because the petitioner's witness, Johnson Nketiah's argument is that the Electoral Commission chairperson breached the constitutional duties that requires of her to be fair in the discharge of her mandate on the said day. And so Mr. Nketiah did indicate that when those mistakes were realized that they tried to inform her, she did not act in a fair manner in listening to them. Rather, she had their representatives send their representatives away and proceeded to announce the results without their consent. Now, you had a situation where Dr. Kwesa White, who testified, is the individual who was at the strong room but says, look, I did not have a direct interaction with the EC chairperson on the 2 days that I was at the place. It's rather Mr. Nunoo who interacted with him.
Joseph, we may have to continue.